My Lord, we'd like to seek guidance on our case, E616 of 2024, Eda Mareta and Agnes Donji, that was scheduled for mention at 9 to 10. It was the first on list before E565 of 2024. We'd like to request to have at least 5 minutes of your time, if you'll allow us, at least for the mention. Thank you. Thank you, my Lord. My name is Eda Mareta.
Your name is?
Eda Mareta. Okay, for us, we are feeling like we could have done the mention today, my Lord, because we have already done our submissions, and they have already done their submissions. So what you're coming to seek today is to get a hearing for our submissions, kindly. And you can see this is a matter of urgency. Already the matter of the former Rigathi Gachagua is now on hearing, and we are also pleading on the same issue of the former deputy Rigathi Gachagua in impeachment in regards to that gender rule. And also, as we seek that, we have a ruling on 5th June on to that gender rule on the 5th bench. So we are just seeking a hearing immediately after 5th June 2026.
You don't want people here to get before you are satisfied by the 5 seconds of hearing, and so that is why you mentioned the matter before for further directions.
Most obliged.
Pomoite for the first petitioner, and I believe the appearances have been recorded. My Lords, in terms of the directions of this Honourable Court, last time we appeared before it, Dr. Gachagua is present in court and he is ready for cross-examination. My colleague Faith Waigua will briefly examine him in chief, very, very briefly, then hand him over for cross-examination. My Lords, Your Ladyship, I'm also, with your permission, happy to report that in addition to Dr. Gachagua, the first petitioner, H.E. regarding Gachagua, and his good wife, Pastor Dorcas, are also present as they are entitled to be. I thank you.
My Lords, on behalf of the respondents, I wish to confirm that our appearances are as before. I further wish to inform the Honourable Court and you, my Lords, that in as far as the cross-examination of Dr. Gachagua is concerned, in the interests of time, we have nominated Dr. Mutomi Diokondu and Mr. Mokele to deal with that aspect of the matter. Thank you.
I think the first thing is for the petition has to lay the ground for this procedure. You are past this stage, so lay the ground for this.
My Lord,
Has to come this side, or has to come back.
my Lord, my name is Faith Waigua. The necessity of why we need to examine in chief Dr. Gachagua is for the sole reason that we've had responses filed by Dr. Kindiki, Professor Kindiki, who is an interested party in the matter. We've had responses filed by the Senate, who are respondents in the matter. And my Lord, there are issues that need to be clarified by Dr. Gachagua in examination in chief. Thank you, my Lord. Thank you, my Lord. Perhaps we could either swear Dr. Gachagua in or affirm him. Yeah.
Some clarification. My Lord, good morning. We were also served with the replying affidavit to the doctor's affidavit, one by Mr. Kindiki and the clerk of the Senate. And also being petitioners in this proceedings, Your Lordship, I'm seeking your guidance, Your Lordship, as to the participation of other petitioners insofar as the affidavit by Mr. Kindiki and Mr. Nyengenye is in issue. Otherwise, our quorum is as before.
My Lord, I don't understand the basis for the direction being sought from you, because you already gave the direction when we were before you that any party who desires to cross-examine the witness now on the dock would do two things. First, they would file a reply to that affidavit. And number two, in that reply, they would intimate whether they wished to cross-examine the witness now on the dock. Mr. Ndego Njiru cannot now purport to be ignorant of those directions, having not done what you directed should be done by anyone desiring to cross-examine this witness. Then he can't come here and just tell you we seek direction on what other petitioners should do.
Thank you for that. The direction which Mr. Ndego has sought. I think directions which what we gave last time are very clear. For you to find or found that this is for examination, you must have responded one way or another. So if you have filed an affidavit, I'll allow you to participate. If you have not filed, unfortunately, you cannot go back.
I'm well getting my.
Thank you, my lord. We may proceed. Please state your full name, profession, and your professional qualifications.
My name is Dr. I'm a medical doctor. I qualified from the University of Nairobi in 1975. I got a master's degree in internal medicine at the same university. I'm a fellow of the American College of Cardiology. This is a giving evidence report. So we want to hear what they're saying and the court.
Speak loudly, Dr. Likonyo, so that their lordships can hear you easily. Okay, the court. Okay, the court has adjusted the microphone.
With the permission of the court, perhaps you could place something under the microphone to just lift it up.
Is that better?
Yes.
Your Honor, again, my name is Dr. Ikonyo. I am a medical doctor, a graduate of the University of Nairobi in 1975. It's 50 years last August. Postgraduate internal medicine, the same university, 1980. Thereafter, fellow of cardiology, and now a member of a fellow of the American College of Cardiologists, trained in Minneapolis, the Mayo Clinic in the U.S. at 1985. Now practicing at the current hospital, previously a lecturer at the University of Nairobi.
Thank you. You have a document titled Affidavit, sworn on 28th April 2026, consisting of 12 numbered paragraphs. Do you recognize this document? Whose affidavit is it?
Your Honor, is mine.
Whose deponent's signature is on page 3 of 5 of that affidavit?
That signature, Your Honor, is mine.
Do you wish to adopt the contents therein as your evidence in this matter?
Your Honor, I do.
Please tell the court whether you are acquainted with any party before these proceedings in a professional capacity.
I believe when the party means the respondent, yes, I'm acquainted with my patient, Honorable Gachagua,
Okay.
whom I have taken care of. From my records, Your Honor, my hospital records that I do have with me, I have been a doctor to the same Honorable Gachagua since, if I could, 5:10 p.m. on the 10th of July 2006.
Okay. When and under what circumstances did you meet the first petitioner, if at all, during the period in issue and relevant to these proceedings?
I believe for the purpose of this issue, we are referring to his hospitalization at the current hospital, which again, from my record, Paddington notes, happened at 3:25 p.m. on the 17th of October 2024. Your Honor.
And what happened when you met him? What happened next?
Your Honor, the reason for his coming to hospital, the court said he's on the way with chest pain, and we received him and acted accordingly.
From your experience and expertise as a cardiologist, what significance do such symptoms have?
Your Honor, you know, chest pain has two categorizations. There's chest pain that can occur if you have a heart attack, medical terms called a cardiac infarction. That, when you say you have chest pain in that category, we look at the possibilities of that being real. That's what we call the risk factors. Here's a man, his age.
My Lord, with a very kind permission. With a very kind permission. I have listened to where the evidence, my Lord, is headed, and in my very humble view, we appear to be expanding the scope of the petition and the affidavit that is before you, Lordship. My Lord, it is important that we stick to what is in the affidavit. For purposes of that is why we are here today. If we attempt to then expand beyond what we agree, then we'll be prejudiced. We'll have to file further affidavits, etc., to be able to respond to the questions that are being raised. We must, I submit, stick to that.
Your final affidavit.
My Lord, if I may respond, I would refer the court to paragraph 5 of the affidavit. Basically, the questions are formulated based on what the witness deponed to. Unless they specifically state exactly what is new, my Lord, we request that you do allow the witness to proceed with his testimony.
Laying a basis does not presume introducing new issues by way of evidence issue. It doesn't mean you then introduce new technical issues that we need to deal with. We'll have to respond to.
I think the way forward is Ms. Oigwa, you will refer the witness to particular paragraphs of the evidence.
Okay. You do have the affidavit with you?
I do have it, Your Honor.
Okay. Please clarify what you meant under paragraph 5 of your affidavit.
Your Honor, paragraph 5 asks, based on my professional expertise, what do these symptoms mean? That the Lord is my answer to that is that based on my experience, those type of symptoms, depending on the probability of the disease, it depends on the risk factors. It would imply that you could be having a heart attack. That is my simple answer.
And based on paragraph 6 of your affidavit, what role or steps did you take with respect to the first petitioner having been presented before you?
Your Honor, if a man of that age and this purpose presents, there are standard protocols that we follow in medicine. We run with that person. In this particular person, my mother named, there was additional risk factors of stress. And stress has brought its own problems of affecting the heart in a condition that we call a purposeful disease.
I refer you to paragraph 7 of your affidavit. Please clarify what you meant in that affidavit on paragraph 7. What examinations did you conduct, if any?
Again, Your Honor, after apart from the physical examination, taking a proper history of the circumstances, then you proceed with specific tests to include what we call a tracing of the heartbeat for Dr. Wiscott or an ECG, an ultrasound of the heart for this purpose of the layman's term, an image of the heart, and blood tests to check for any heart matter damage. Again, Your Honor, it's all
Madam, very kindly, as my Lord did direct, could we be pointed to specific parts of both the affidavit and the attachments that then align with what the good doctor said, my Lord? My concern is one, my Lord. We, by seeking clarification, we are then proceeding or extending beyond what is contained in the document. It then leaves us in a very precarious position in terms of this.
The doctor is here to give us experts. And we must be in the mood to do that.
Yes, my Lord. Can we clarify, my Lord, beyond that contained in the affidavit?
My Lord, if I may assist the court, the issue being raised is we have a written affidavit, which is sworn testimony. Ordinarily, that would be the evidence in chief. The second issue is that it is trite that where a thing has been reduced to a document, in this case, the affidavit, and the annexures thereto, you cannot, under the guise of examination in chief, purport to add to subtract from, to contradict, or vary. Even if this witness were to spend 2 days here, offering these things now being called clarification, it's just a waste of your time. Section 99(1) of the Evidence Act says that evidence is inadmissible.
I've been submitted a very brief reply. The rule of objections, as I know them, is that you object to something, objection irrelevant, objection something. There's no specific objection. You're being told that the objections, without a proper basis, we kindly request you to order that the examination in chief proceeds and concludes very shortly. Then my learned friends would have their time to impeach and to do anything lawfully the witness understands. Thank you, my Lord.
And so when we proceed with the latitude that those paragraphs in the affidavit gives you, and I think we must understand that we have an expert witness. It's a reason why we call him an expert. He has come to tell us something we may not know. Therefore, within that latitude, please proceed.
Thank you, my Lord. So what you are referring to was in paragraph 6 of the affidavit?
Your Honor, exactly. That's the question. The things I've mentioned are in that affidavit. The ECG, for the Dr. Gachagua, the blood test. I've not
Thank you. Please refer to paragraph 4 of your affidavit and annexure marked DKG 3. Annexure marked DKG 3. Can you explain the timings reflected in those documents? Paragraph 4 of the affidavit, which talks on when you approximately met the first petitioner, DKG.
That was on the day of admission, which we just clarified just now from my handwritten note of the hospital notes, which was on the 17th of October 2024 at 3:05.
Now, my lord, now the witness is confirming why you're hearing objections. The witness is referring to his handwritten notes, which are not attached to the affidavit.
My apologies, Your Honor. I will not refer them.
Okay, please refer to paragraph 4 of your affidavit and annexure DKG 3. That annexure is titled Discharge Summary.
I think you should have somebody assist the doctor.
Yeah.
But you know exactly what point you are on.
Yes. And there are timings mentioned in paragraph 4 of your affidavit, and there are timings indicated in the discharge summary. Could you explain those timings?
The date of admission, the date of discharge, population.
Yes.
Your Honor, this is the day of discharge, the day of admission is the time that the patient was admitted to hospital. As I mentioned earlier, it's written here as 4:18 p.m. I would qualify that, Your Honor, that we must understand what admission is.
No, my lord, that's exactly what the law says the witness can't do.
Yes, that one can't do.
That is the Your Honor,
What you should try to avoid is any interpretation of the document outside the document.
no problem. Admission time 4:18 p.m. 17th October 2024. Discharge 20th November 2024, 1:06 p.m.
Okay. Under paragraph 4, there is a timing of 3 p.m. What transpired at that time?
3 p.m. is the time of admission that the patient arrived in the hospital and was given a headache.
Just a clarification. 3 p.m. and there is the 4:18 p.m.
That's what I was going to, but I was stopped from saying.
Please clarify those.
If I'm allowed.
What happened at 3 p.m.? What happened at 4:18 p.m.?
My lord, we still retain the objection. It is in black and white in the Evidence Act. If it is in the document, no amount of oral evidence from this witness can be admitted for purposes of adding to, subtracting from, clarifying, or all these things is now purporting to do.
Your Honor.
Let me rephrase that, Your Honor, and because the times you've read them out, when did you see the patient? What time did you see the patient?
3:25.
As per paragraph 4 of your affidavit, what time did you see the patient?
Approximately 3 p.m.
Okay. What time was the patient admitted to hospital?
At that time that I talked about,
Which was?
3 p.m. But on the paper here, and you must allow me to clarify because you have to understand why that date is there, why that time is there. That's why we are here, to explain to you the discrepancy between 3 and 4. Your Honor, if you allow me, I'm an answer to that.
Just answer what
Yeah. Answer. Proceed.
The discrepancy is because as one comes to hospital, that is not admission. Admission is when the technical details are entered in the admission papers after all other factors have been taken care of. Who is the insurance, who is paying, and then the account department will put that time after admission time.
Okay, thank you very much.
If there's no cover for that, you will not be admitted. You will be seen.
Thank you. Thank you, Dr. Now, refer to paragraph 8. Paragraph 8 of your affidavit and the annexure again marked DKG3, which is the discharge.
On the past point that you made, on the affidavit you say you were discharged on the 20th of October 2024.
Okay.
On this other case, it says discharged 20th November. There's no error in that. If your honor allows me, I can explain why that is so.
Please explain.
The answer is again, discharge process in hospitals involve accounting. You must pay before you are discharged. And then if you have been discharged by the doctor and you've been gone home and you're not paying your bill, you are technically not discharged. We call it an open bill. It's just when you come and clear all your bills and everything else, that you are technically financially discharged.
Thank you. Refer to DKG3, the annexure, which is a discharge summary, at page 4 of 4. Who wrote the discharge summary? Who wrote the discharge summary? It's at page 4 of 4.
Your Honor, if you allow me, I have to define what we mean by writing a discharge summary. Because our hospital, current hospital, is a training institution. You have medical interns, you have medical registrars, you have junior consultants, you have senior consultants. And the typing of the discharge summary, printing on the computer, is done by either the officer or the registrar or the intern. In this one, it was done by Dr. Sarita. But the consultant operates what has been typed in there and signs that is correct. So it was prepared by Sarita and signed by me, Dr. Sarita.
Okay, thank you very much. Still on page 4 of 4 of DKG3 annexure, which is the discharge summary, what did you mean by the follow-up, that ongoing review, follow-up?
I believe in medical terms, what we mean by follow-up in the discharge from hospital is that although you have been treated, there are issues that need to be followed up. How are you faring? We actually, at the current hospital, actually call patients at home and ask them, you are discharged last week, madam, how are you faring? But more than that, we give you an appointment to come back. Just to make sure what we did was correct, and you're getting better, and if anything needs to be done, and then most of the time, you have to make a hospital lifetime follow-up.
Okay. Is annexure marked DKG3 to your affidavit true and accurate copy of the original discharge summary?
Your Honor, it is.
I'll go to the last bit. During the period the first petitioner was under your care, what communication, if any, did you receive regarding his condition from anywhere?
Oh, Your Honor, there are always follow-up calls, relatives, and friends. But in this particular case, Your Honor, I must be honest enough to specify that I did receive a call from our president asking about the status of the patient and for the appointment.
What did you communicate in response to that inquiry?
For the first time, Your Honor, I just say that we are in the process of doing various tests, and as soon as we have a conclusion, we shall let it know.
Okay.
But Your Honor, you must allow me to say this, that when I say that, I have to seek appearance from the patient that was spoken so to prove physical information.
Okay, very well. On my second last question, please refer to paragraph 10 of your affidavit. Paragraph 10 of your affidavit. And annexure DKG4.
Yes, Your Honor.
And tell this honorable court the relevance, if any, of the annexures in relation to your testimony.
Your Honor, during this hospitalization, this hospitalization for reasons that happened that time in a public issue, and there were public notices in newspapers and television services covering the issue.
Okay. Lastly, please refer to paragraph 11 of your affidavit, and in summary, what you'd like this honorable court to understand regarding the first petitioner's admission and treatment.
Your Honor, I've only one statement to make, and that the Honorable Gachagua was admitted to hospital on the date so specified and discharged on the date so specified and treated according to the terms of medical practice.
Thank you very much. That is all, my lord.
Good morning, Dr. My name is Mudhomi. I think we know each other. Yes. I will ask you a few questions on behalf of the respondents and the second interested party, who is the party I represent in this case. For the record, please confirm that your affidavit is dated 28th of April, the year 2026. You will agree with me, sir. This affidavit has been made 1.5 years after the events described in it. Correct or incorrect? It's correct. Was this affidavit placed before the Senate? The request has come now. You don't believe, sir, it is bizarre that a request of this nature in a case of this nature will be made 1.5 years down the line? Would you agree with me? That's bizarre. It's not natural.
Sir, I don't know the proceedings.
Okay. Fair enough. This affidavit has attached some medical records, Exhibit 3. Correct or incorrect?
Correct.
That exhibit, was it placed before the Senate?
I won't be aware, sir.
You are not aware. But you will confirm whichever date we take from the multiple dates on it. These are again events that this document was available about 1.5 years ago by the date given there of 17th October, isn't it? You have to agree this document was available.
Yes.
You also have to agree that with due diligence, this document would have been placed before this honorable court about 1.5 years ago. True or untrue?
No opinion, sir. I don't know.
No opinion? Fair enough. You have now attempted to explain a discrepancy between paragraph 3 of paragraph 4 of your affidavit, it talks of 3 p.m. But Exhibit 3 at the top right talks of 4:18 p.m. You agree that's a discrepancy on its face? On its face, without more looking at it, is there or is there no discrepancy?
None whatsoever, sir.
Are you saying 4:18 p.m. is the same time as 3 p.m.?
There are different times for different.
They are different times. Therefore, you agree with me, sir.
My Lord, could the witness be given the opportunity to complete answers to his questions without being cut short?
Dr. Gikonyo, is it your testimony that the time 3 p.m. given at paragraph 4 of your affidavit is the same time given as 4:18 p.m. in the medical record?
They are different
Good. They are different times.
occurrences. They are not the same thing they are describing.
Okay. This explanation you are now offering on the witness doc, is it given anywhere in your affidavit? The explanation for the discrepancy, is it set out anywhere in your affidavit?
It should be understood.
No, the question is it set out anywhere in your affidavit? That explanation you are now offering in court.
Not there because
It is not there. Good.
never raised. Otherwise, I would have given an answer.
We are here to raise it, unfortunately. Let's stick to that page 104. Dr. Gikonyo, you have to agree with me that we identify individuals in Kenya by reference to their national identity card or passport number. Correct or incorrect?
Depending on the purpose, sir. In my class, they call me DK.
Does this document indicate the identity card of the patient being attended to? Does it indicate the identity card number? National identity card number. Either it does or it does not.
We have the client ID number.
That's not my question, sir. My question is, on its face, does this document disclose the national identity card of the patient it describes?
Deliberately not.
Good. Does it indicate the travel passport number of the patient?
Deliberately not.
Good. Deliberately not. Very good answer. Does it give the patient's name?
Deliberately not.
Therefore, you have to agree with me, sir. A document that does not contain the patient's name, does not contain the patient's national identity card number, does not indicate the passport number. We have no way, based on the document, of ascertaining who is the patient described in that document.
We do have to ask the person who prepared it.
No, the person on the doc is you. Does this document on its face, sir, disclose the identity of the patient described there?
Only by initials, RG.
RG, which could mean anything, isn't it?
To other people, but not to me.
Okay. Fair enough. I put it to you, sir, that you having brought this document to court, you cannot run away from the fact that it doesn't disclose the identity of your patient.
Deliberately so when it was prepared.
Okay.
Now I can disclose. If you ask me who it is, I'll tell you. RG
RG could as well be Rob Gitau, right?
could be, but it is not.
It could be Ruth Gitanga.
It is not.
I put it to you, sir, it can be anyone and anything.
In this category, no.
Okay, fair enough.
You can ask me who is RG. I will tell you who is RG.
The problem, doctor, is we don't believe you. That's why these questions are being asked.
You ask me, why did you write RG? I can't ask
It is me who chooses, unfortunately, the questions to ask. So, let's go to that. The title of the document is a medical summary.
Correct?
You have to agree there is a difference between the summary and the primary document.
That's true.
So, has the primary document been placed before this court? Can you see it anywhere in your affidavit? You can take time to flip through. It is not in your affidavit. You have to agree with me, therefore, in the absence of the primary document, an independent reader has no way of confirming whether this summary agrees with the primary document. No, on the documents, we are dealing with the document. In the absence of the primary document, would the third party have a way of confirming whether the summary is accurate?
That document was adequate in itself. I will not be here. I am here to answer questions pertaining to that document. You say it was correct. If it was adequate of itself, you would call me here.
We actually called you, Dr. Ikonyo, because the document has just too many gaps. Let's go to the paragraph of your affidavit that talks of the 48 hours to 72 hours. That's paragraph 7 of your affidavit. If that were true, it would mean this patient, and we mean patient RG, whose identity we don't know, it would mean that this patient would have been discharged on or before 20th October 2024. Correct or incorrect? We are following the document, sir. Your paragraph says he was admitted for how long? 48 to 72? Your paragraph 7.
Sir, please read correctly. We compared it.
And when does it say he was discharged?
On the 20th
Of which month?
of October.
Of October. Good. And what is the discharge date given in the medical summary? November. That's actually 34 days later.
Correct.
Correct?
Yes.
You have now attempted in your exam in chief to explain the discrepancy.
Not attempting. I give a
Okay. Let's take it you have explained. You have explained while on the witness dock the discrepancy of 34 days, right? Is that explanation set out anywhere in your affidavit? The explanation you gave this court for that discrepancy?
Yes. This is understood.
No, my question is the explanation you are now offering 1.5 years later, is it said, show me the paragraph of your affidavit that explains the discrepancy?
It was not required.
It was not required. But for the record, is it given in your affidavit, that explanation?
Not given because not
Good. It's not given. This summary gives the patient. Can you see that part of Exhibit 3?
I do, yes.
It begins with yourself. Who are the other doctors?
Your Honor, if you allow me to explain.
You can look at it.
Anyway,
I haven't asked the question for you to explain. You can only answer questions I ask.
I know the names.
The names given there.
Yes, I can look at them, but I know them.
You know them. Good. Is the maker of this document one of the doctors who are indicated as attending to this patient? No. So we don't have the primary document, and we have a summary made by a person who did not attend to the patient.
Not correct.
Not correct. Is Dr. Sarita, just for the record, indicated as one of the doctors in this summary who are attending to this patient?
She is not a consultant.
My question is she indicated as one of the doctors who are attending to the patient? From the list given at the top, is Dr. Sarita one of them?
Your Honor, I must explain what this list of consultants mean to the audience here.
We are not interested in that. The question is she indicated? Either she is, and Doctor will add quickly if you answer the question. The more we kick about the bush, unfortunately, the longer time we will take.
But I can't allow you, sir, to proceed on a misunderstanding.
My Lord, the witness has no...
Excuse me, Dr. Kari, you claim that the evidence will answer questions as put to by counsel without any
But Your Honor,
evaluation. Just answer the questions as put to you. If you don't know, you say you don't know. Then you proceed.
And that's how the law works, Dr. Gikonyo, just for the record.
thank you. I understand now.
So is Dr. Sarita indicated in this document?
Should you find that there's a need for clarification, they will ask you to clarify. All right. Yes. Go on.
So, Dr. Gikonyo, is Dr. Sarita, the maker of this summary, indicated as one of the physicians that were attending to the patient, known as RG? On the face of it, is she indicated in the list of those doctors?
Not as a consultant.
Is she indicated in any other way?
As a preparing, as the one preparing.
No. That's not my question. Just wait. Is she indicated as attending to the patient in any medical capacity? The maker of this document.
Taking care of the patient are not listed.
I thought they are listed here, sir, about 6 of them.
These are the consultants. There are other doctors in the system, medical officers, intensive care doctors, and other people. And as I mentioned earlier, we are a teaching hospital.
Is there any material you have placed in your affidavit to show those other doctors and the fact that they were attending to the patient?
No.
Good. In fact, on the document before the court, we have no way of knowing who else other than the 6 given that attended to the patient.
Only by asking the person of the doctor,
No, we are talking on the document, sir.
not on the documents.
Good. Let's go to the bottom of that document. Bottom left. That document has a computer timestamp at the bottom left, correct? Bottom left, below prepared by Dr. Sarita.
2011, 24,
12:40
1240.
p.m. So what is the date and time of this document's preparation as per that timestamp? It is prepared on the 20th of November 2024 at 12:40 p.m. Correct or incorrect?
Right, that's correct.
Now let's go to the opposite side of the page, bottom right. What is the date and time given? The date you confirm,
20, no,
correct or incorrect?
that's correct.
You must agree, sir, that it is not possible for this document to have been prepared at 2 different times as it purports to say.
I put that aside by the computer without checking that.
Unfortunately, sir, you have to agree with me that on the face of it, this is a discrepancy as to the time when this document was prepared. It has 2 timelines. Which one do we take?
I do not know.
Good. You don't know.
I would add to the first.
You have testified that this patient at the prior history, we go to page 204,
Yes, Your Honor.
and you have summarized it there.
Yes, Your Honor.
Have you placed before this court any primary documents to prove this alleged prior past medical history?
Why is it available?
No. My question, sir. Have you placed before court any material to show that this patient had prior history of the conditions described there?
None at all.
None at all. Good.
Why, Your Honor?
None at all.
It's available. I have it from you here today.
Unfortunately, it's you who testified on affidavit on oath, sir, that he has past history. So you have to agree with me then, in the absence of that material on the record, this is just an allegation. We have no way, based on your affidavit, to confirm that the patient described there had this prior history.
You have no way, but if you are interested in knowing, it can be provided.
Doctor, you say you did a number of tests on this patient,
Yes, Your Honor.
including an echocardiogram,
Yes, Your Honor.
2D, one is called 12 LED and the other one 2D, right? You must agree with me that that machine for echocardiogram generates a report and a graph, correct or incorrect?
Of course. Yes, it does.
Yes, it does. Have you in this affidavit attached that graph that the machine generates to show that the patient has the conditions described in the summary?
No, it's not. Available is required.
No. My question is, have you attached to the affidavit the report that the echocardiogram machine generates?
Definitely not.
Good. Have you attached the report that the other machine automatically generates?
Not attached, but exists.
Fine. Have you attached the images that were supposedly taken of this patient?
If I thought they would be useful for this court, I would have attached them.
Fair enough.
I thought of those and necessary to attach them, but they are available if required.
But you would agree with me that the images and the graphs and the reports would be the primary document evidencing the illness, correct or incorrect?
Correct.
Therefore, if that is correct, you must agree with me that this summary, in the absence of those images and those graphs and those reports, cannot be the evidence that patient RG had the conditions described in your affidavit.
Unfortunately, I would not agree with you.
Fair enough. You say he also took some blood tests.
Yes, Your Honor.
Have you attached the laboratory report of those blood tests to this affidavit?
Required, they can't.
No, doctor, my question is,
They're not attached.
have you attached
Deliberately,
the laboratory report of the alleged blood tests?
deliberately not. Available if required.
So again, based on your affidavit, you have to agree. We have no way of knowing whether there were blood tests or what were the results of any such blood tests.
I disagree. We have a way of knowing. Ask them and produce it.
Page 3 or 4 talks of hemoglobin, platelets, and blood chemistry and other things. Correct or incorrect? Either it does or it doesn't, Dr. Ri.
It does.
Do we have in your affidavit the primary document, that is the laboratory report for all these tests?
Available if required.
No, my question is, do we have it in your affidavit?
No, they're not.
Definitely not.
Yes.
In page 404, there is some information there about follow-ups. Have you produced before this court any document on that follow-up?
Has not been requested.
The question is, have you annexed it, sir?
No.
You have not annexed it. So again, I put it to you, there is no material before this court to confirm there was any follow-up. Dr. Gikonyo, in summary, you have admitted you have no material before court to show the prior history of the patient. You have confirmed there is no material before the court to evidence his medical condition when you supposedly attended to him. And there is also now no material of the follow-up. Is it not because this gentleman was in your hospital to hide away from the Senate? He was not sick. I put it to you.
Let me laugh a little bit.
Trust me, I too have been laughing about it.
But honestly, sir,
Yes.
the question arises as to those documents that have been raised, if they are available, and if you are looking for justice and honesty, you can ask me to provide them. And it takes 2 seconds. They are here.
Yes, you may have them, but they are not on the record, sir.
You can have them.
Unfortunately, the law does not permit you, Dr. at this belated stage, to even refer to them, because they should have been put on the affidavit. But to my summing up questions, your affidavit alludes to some media coverage of his alleged illness. Did you give yourself a press conference on this illness?
Yes, Your Honor, on demand from the press.
On demand from the press. Dr. Gikonyo, is it standard medical practice for doctors to give press conferences as to their patient's illness?
Depends on the sensitivity of the
No,
issue.
the question, sir, is it standard medical practice for doctors
Yes, when
to
it's
call press conferences?
No, sir. We don't call for press conferences.
Okay.
Press comes to us.
When you are giving this press conference, the case before the Senate was proceeding. Correct or incorrect?
Most likely so.
You found time to give a press conference, but you didn't find time to go and tell the Senate. Okay,
In what capacity would I go to the Senate?
good. Wouldn't the Senate, where the proceedings were going on, sir, have been the natural forum for you or any of your colleagues to go and tell Senate that the witness cannot come because he has been admitted in hospital?
I'm not sure if access to the Senate is available to get the common person like
That's all from me. I will yield the floor to Mr. Mukele, my lord, to wrap up the cross-exam.
My lord, there is a serious allegation in the form of a question raised by Dr. Thionkulu that Dr. Gachagua was hiding the first petitioner. That was posed, and I'm not sure that Dr. Gachagua was given the opportunity to respond.
Just for the record, the witness answered, and he said his answer was to laugh.
We'll deal with it. We'll deal with it, yes. Thank you.
My lord, my lords, Ladyship, Senior Counsel Dr. Thionkulu has covered quite a bit of ground. I will only have about 3 or 4 questions for these witnesses. I don't think I have much to add. Good morning, Dr. Gachagua. My name is Edwin Mukele. I represent the 3rd and 4th respondents. I've been permitted by Senior Counsel Professor Ojienda to ask 1 or 2 questions on behalf of the Senate and the Speaker. Now, I had your last comment to be that you are not sure, and this goes to Dr. Thionkulu's very last statement, you're not sure whether you have access to the Senate. That's what I heard you say, correct?
Yes, I said so, sir.
Now, Dr. Gachagua, presented before court, is sworn on the 28th of April 2026.
That's correct.
That's correct. Do you recall when the first petitioner was impeached?
Not exact date, but I believe the same day that went to hospital.
The same day that he came into hospital. Would that be the 17th of October 2024?
Most likely so, sir.
Most likely. This is about, we then receive your affidavit in court about 1.5 years after he has been impeached.
That's correct.
Now, going back to your evidence, and I'll be very brief, my lord. When asked a question on whether the documents you presented would have been presented to the Senate, your answer was, the request has come now. That is what I heard you to answer to one of Dr. Thionkulu's questions, yes?
That's why I'm here.
The request has come now.
That's why I'm here.
So the request, Dr. Gachagua, to file the affidavit and the attached documents has come now. That is what you said, yes?
Yes, I know, yes.
From whom did you receive the request?
From the petitioner.
You received the request from the petitioner.
Yes.
Do you recall, do you know, when the petitioner first filed the petition? Might you know?
Do I know? I know.
You're giving evidence and you're not interested in the context of a petition in which you have no interest. Is that what you're telling the court?
Yes, that I'm here purely on a medical issue, not a court issue.
That is startling, Daktari, I must say. It means, in my view, you probably don't understand the reason you're here. But I will go on. You have also, and this is my last question, mine are very brief. You have also confirmed that you did not know whether the affidavit and the documents attached were before the Senate. Do you have any information on that? You don't have any information on that?
And I agree with you, sometimes I really don't know why I'm here. My understanding is I'm here to answer medical questions about the professional injustice.
So,
About law things and forth and things,
so,
I am ignorant.
so Dr. Gikonyo, Dr. Gikonyo, you cannot tell the court, from what I understood, whether the affidavit and the documents presented today, sorry, the affidavit sworn by yourself on the 28th of April, were before the Senate at the time of the impeachment proceedings. You can. You only know. That's okay, Doctor.
I have no interest in those matters.
That's okay. That's okay. We understand that you do not know why you're here. My Lord, those are my very brief questions on behalf of the Senate. I beg to. Thank you.
Dr. Gikonyo?
My Lord, we had Dr. Kamoto to ask just two questions, then the witness can be re-examined. If you permit him, please.
My Lord, there was no affidavit filed by Dr. Kamoto, and you have given directions before the commencement of these proceedings.
Yes, my lords, my lady. We have put our responses. We are doing a joint approach to this matter. We have a joint approach to this matter, and that's why you'll find, my lord, that not every one of us makes submissions or presentations on every occasion. Otherwise, very well. We are most obliged.
My Lord, I'll proceed with the re-examination of Dr. Gikonyo. Very quickly, Dr. Gikonyo, I'll refer you to paragraph 11 of your affidavit on the reason why you filed the affidavit. Could you come clear or clarify why you swore this affidavit, referring to paragraph 11?
Because as far as I'm concerned, Your Honor, that paragraph summarizes why that I made this affidavit in my capacity as a medical expert, not a legal expert, in other cardiology, to assist this honorable court in establishing that the first petitioner was duly admitted to hospital on the date in question and underwent treatment. That is what my understanding.
And you had earlier confirmed that the contents of your affidavit were true, to the best of your knowledge. Thank you. Just to clarify a few issues that have propped up during cross-examination, and I will go back to paragraph 4 of your affidavit, and I'll be direct this time round because it cropped up. Is there any admission issues in paragraph 4?
None at all.
Thank you. So at 3 p.m. on 17th of October 2024, what exactly happened?
At around 3 p.m. is the word. Approximately is the word.
Yes.
You want to know the exact time we have treated Cyber.
What happened?
About that time is when the petitioner arrived in hospital.
Thank you.
We took him in. We started the normal thing that we do for treatment taking, taking spirit, blood pressure, and such. At that time, we allowed the president It's the time of we start now the admission process.
Thank you.
Admission is a process, not an instant.
And
as we are doing those things, the accountants asking who's going to pay for this, blah, blah. And when they are ready, then they fix on a computer, this is mine, now.
so when was he admitted?
According to our document here, 4:18 p.m. That is when the actual documentation of admission were completed. These are technical details of timing and writing. Before that time, we are still seeing the client. We are doing the necessary things. But it's technical, not admitted, because the accountants are not allowed us to do that.
Thank you. I'll refer you to page 1 of 4 of the discharge summary. And on the top, the patient name is Mr. RG. Who is RG?
You know, Your Honor, if you come to hospital and you are an ordinary citizen, you put your full names or your other names. There are clients we don't put names on record.
My Lord, we still object. That evidence is extrinsic to the record. It is inadmissible. And my good colleague here knows that question is also impermissible.
The question was actually raised in cross-examination, and what we are seeking is a clarification on who RG is.
Your Honor, I have said, our practice in the hospital protects privacy because this document go around hospitals. Malaria Paradise Hospital, Ground Life, we use a codes.
Okay, but who is RG? Who is RG? Okay, is there any other identification information in that document? Have a look. Is there any other identification information with respect to that, without necessarily reading it out?
There's a mobile person about it.
Thank you. Would you confirm whether there is any discrepancy between the affidavit and DKG3, the discharge summary? Thank you. And lastly, is DKRG, what document is DKRG? Because there's been an allegation of a medical report. What is DKRG? It's a discharge summary.
It's not a medical report. A medical report gives details that may not necessarily be required by this court. But if required, Your Honor, it's available.
And in your discharge summary, you were confirming what you deponed to in paragraph 11 on the purpose of the affidavit.
Absolutely.
Which is admission, discharge, and treatment.
Absolutely.
Thank you, Your Honor. That's all.
Just one very brief question, Dr. Gikonyo. It was put to you by Dr. Thionkulu that you admitted the petitioner, His Excellency Rigathi Gachagua, to hide him, suggesting he wasn't sick. And I think you responded by laughing. Now that you have finished laughing, will you please answer the question? Was Rigathi Gachagua sick or not sick? Why are you hiding him in your hospital? Please answer. It is a serious question.
I must say I laughed because I thought it was not a serious question because maybe it's not common sense. But however, the answer is yes, he was sick. We admitted him. We have data that's available to any medical person. We have medical reports. We have traces of his ECG, his echoes, everything. We have data that's available on demand by this court.
And apart from the documents, Dr. Gikonyo, you are here as a doctor, head doctor who was treating him.
Your Honor, that's why you called me to answer those questions.
That's all, Your Honor.
The affirmative. I was the one who was treating him with my team. He was sick. We data, we have provided an affidavit. If there's any further questions, we have provided.
That's all, my lord, your leadership.
Thank you, Mr. President, for coming to clarify those issues. You may now take your seats.
My lord, can Dr. Gikonyo be released as a witness to go back to his seat? Okay.
You can be here or you can go
Oh,
home.
okay.
Would be asking for specifically is about, well, my lord, you know, you have previously sat up for about 10 p.m., but I wanted to get your direction so that we also know how to budget and plan as to when we'll be ending, so that we know which testimonies you take and whether or not you'd want to have us progress with the submissions this morning.
I think, Mr. Gumbo, before we give directions, we probably want to know how many of you will be addressing the court and what directions do you require with respect to the cross-examination that has just happened. Will you follow that up by making oral submissions so that we don't have to take written?
So, my lord, we will, in the course of making our oral submissions, be also submitting on what has transpired during the cross-examination. So that need not bring any complication. The respondents will deal with the issues in the course of highlighting their written submission.
So that leaves Mr. Gumbo and...
So, my lady, on behalf of the National Assembly, we will have 4 of us making our submissions. We do not expect to go beyond 2 hours.
Yes, and that is for the National Assembly.
That's for the National Assembly.
Yes, Your Lordship, my lords, on behalf of Senate, I will lead the team and will be on point. We'll be assisted by 2 other counsel on other questions. Not more than 2 hours. I think I should take not more than 2.5 hours. I'm normally very brief.
My lord, on behalf of Professor Kidure Kindiki, we also need 2 hours. We'll be sharing the time with the team that I lead.
On behalf of the Attorney General, I wish to confirm that we do not wish to make any further submissions, as we believe that our submissions were clear and nothing we have had since we made them has changed that position.
Your Lordship, if I may, on behalf of the 9th respondent, we require about 45 minutes.
My lord, for the 10th respondent, we'll just do 1 hour.
Okay.
On the part of the commission, we'll take about 8 minutes.
Which commission?
The IEBC. The 16th respondent.
My lord, may I suggest that perhaps we start with the IEBC, which is taking 20 minutes, and then we come to the parties who wish to take longer. And also wonder why my learned friend Dr. Thiankulu would require the same amount of time as the primary respondents. He is really an interested
I think those submissions were being made on the light of the knowledge that I divided by half. I will certainly will not give you 2 hours. I'll not give you 2 hours. I'll not give you 2.5 hours. That will give you sufficient time for you to make coherent submissions in this matter.
Our only concern is parity of arms. That side took about 10 hours. 10 hours. So we'll be taking less, even if you add all the times that they took. Yeah, even when you subtract the half, they still took 10 hours.
They did not, but we'll give you sufficient time.
My Lord, for the record, for the Speaker, my Lord, Milimo, my Lord will be taking not more than 30 minutes.
That's 15, that's good. So can we have the person who will set the pace, 10 minutes, IEBC.
If it may please you, my Lord, my name is Kibe Mungai. I appear with Mr. Kamwaro and Mr. Peter Koira for the 10th to 41st petitioners. We made our submissions on our petition last Thursday. My Lord, we are here for the simple reason that the following day, on Friday, the Constitutional Court of South Africa rendered a decision with regard to an issue of presidential impeachment that directly deals with part of the issues that was substantially raised on behalf of the first petitioner and by the 10th to 41st petitioners. A judgment that is directly relevant in this matter. Being proactive, yesterday, the 12th of May, we filed supplementary submissions to bring, which we have served all the parties, to bring that issue to the attention of the court, and with a view that the supplementary submissions that we did, the court may certify them as duly filed so that they become part of the record of our submissions, and today, so that to enable the other side to respond, to be able to seek directions of the court on how we should progress based on that issue. We make this request for the simple reason that the Supreme Court, in the case of Sonko, that has been cited severally, indicated that the advocates and all the parties and the court have a responsibility to ensure that cases are decided on the basis of all relevant matters of law and fact and the best research that is possible. So we are under duty, and we have done something direct, proactively, to certify that duty, that this is a decision that needs to be considered by this court. And the right procedure, if I may be asked, is that I would be requesting that within 30 minutes, I can formally, before they start, because it is a matter they would have a right to respond to summarize what are the issues and brief reasons why that decision should be incorporated and the sense in which it should be understood by this court as part of the petitioner's submissions. I believe in particular the first petitioner, whom Mr. Ochiel said a lot of things about that issue of the Senate and the Special Committee, would have an interest in that particular matter. So may I request for directions on that issue. It is already filed, the decision is also filed, so that all that would be required would be to hear what would be the best way to proceed before the respondents have started. I believe, in view of the proceedings that have taken place, the petitioners have just closed their case for today. Only that my learned colleague, Professor Muigai, had made submissions on behalf of the client Attorney General. So that's all, my lord.
My lords, we became aware of this decision as soon as it was issued, and this is largely due to my younger learned friend who circulated it, and for which I thank him. It's a very weighty decision from the Constitutional Court of South Africa. It will be our submission. It is totally irrelevant. What I would propose we do, just like my learned friend Mr. Kibe Mungai has done, he has filed his own submissions on it. I would beseech my lord to open the same path to anybody who wants to submit on it, and we leave it at that. We do not wish further time be expended on this is the court, this is the judgment of a foreign court about foreign law. So it should not detain us, and we should proceed as my lord has suggested.
That's a sensible suggestion on our side. And you also think that the court can save time for rejoinder by allowing most of the petitioners to make their rejoinder in writing that way, and then the wish to conclude today could be achieved.
Mr. Kibe, you look...
It's just that it is irresistible for the first petitioner to join issues, Professor Gidu Muigai, that this decision is utterly irrelevant.
It is?
He said, he told this court that the decision is utterly irrelevant.
I thought you were confirming that.
My concern is that there cannot be a more relevant decision on the attempt to avoid a committee of parliament to do the investigation, and on the jurisdiction of the court to question actions and decisions and resolutions of parliament. This decision answers to those two issues, but if everybody gets leave of this court to put in written admissions on that point, then I'm in agreement with senior counsel, Professor Gibu. Thank you.
I knew, my lords, one day before we retire, my learned friend and I will agree on something.
Thank you very much. I think we have more or less agreed that we treat Mr. Kibe's submissions on that issue. We allow parties for submissions on that issue. And between now and then, and the time we retire to write our ruling, if you have an authority, just file it. Just file it, we'll consider it. Only that we shall say something about it during the rejoinder. All right, that is okay. Thank you. Yes, IEBC.
My lord, we have Ms. Joy and Mr. Nura. I think the president called.
We will particularly take note of time.
If your lordship could give me a second to catch my breath. It's a hassle to get from the back of the court to the front. pleases my lords, my lady, my name is Noura Abdul Kadir. I appear alongside Ms. Joy, Ms. Faith Kiende, Mr. Derek Asala, and I also hold brief for Mr. Mahat Somani for the 16th respondent, the IEBC. And together with these oral submissions that I will make, the 16th respondent also relies on the submissions he filed on the 25th of October 2024, 27th of October 2024, and the replying affidavit sworn by the then CEO, Mr. Marjan Hussein Marjan, sworn on the 25th, my lord, of October 2024. We will be relying on those documents, my lord. We will briefly highlight on a single issue, my lord and my lady, and that issue is the IEBC's involvement under Article 149 of the Constitution regarding vacancy of the office of the Deputy President. And the main question that we will be asking is whether the Constitution contemplates any role by the IEBC in the filling of that vacancy. My lord, Article 49 identifies two actors expressly. That is the President and the National Assembly. Therefore, the question that arises for this court's determination is whether, beyond those two expressly identified individuals, those two expressly identified actors, does the Constitution intend any additional role for any other actor, but for purposes of this submission, the IEBC? My lord, it is our humble submission that that particular article is deliberately narrow and precise by design. It provides two constitutional actors and two constitutional functions. First, the President, who nominates a person within 14 days. Second, the National Assembly. So on a plain reading, my lord, of that article, the Constitution does not introduce any third actor, any intermediary, institution, or any additional clearance mechanism where IEBC would play any particular role. And my lord, in answering this question, and because these submissions have been made severally before this honorable court, is what would have been or what could be the intentions of the drafters of the Constitution. And in asking ourselves this question, my lord, we interrogated the harmonized draft and the Bomas draft 2004. Under Article 168 of the Bomas draft 2004, my lord, the process was expressly confined to the President and Parliament. And while this process was a bit more complex than what we have in our present Constitution, involving both houses of Parliament, it still made no mention of the IEBC. intended. It could be easier to just reach out to Professor Gilmiga and ask him what he intended. But it is clear from those two drafts that there was no intention to involve the Electoral Commission. Therefore, we ask ourselves, where could the qualms and the quarrel by the petitioner have arisen against the IEBC? And that would fall on one article of the Constitution. That is Article 148, the qualifications of a deputy president. If you look at the qualifications of a deputy president under Article 148, the Constitution references you to the qualifications of a president in 137, which further references you to the qualifications of a member of parliament, which is Article 9. My Lord, it is our submission that the petitioners proceed from an assumption that the IEBC must therefore undertake a formal verification or a clearance exercise as though the filling of a vacancy under Article 145 were an electoral process, which we humbly submit that it was not. My Lord, it is our humble submission that if there is any role that is not expressly stated or implied under Article 149, it would be to the two actors who have been mentioned in that article. That would be the President and the National Assembly. To satisfy themselves that the nominee meets the constitutional requirements of that office. My Lord, in that context, and seemingly out of abundance of caution, that we submit that the President sought factual information from the IEBC. And the IEBC merely responded with information that was within its custody, whether or not an individual is within the voter register. My Lord, we submit that up to that point, up to the point that the IEBC provided that information, it was not under any constitutional obligation or duty under Article 149. It simply provided information that it possessed. Now, my Lord, the other qualm that the petitioners seem to have is whether the information issued by the IEBC was improperly provided by a commission which was not properly constituted. My Lord, I humbly submit that this particular issue has been heavily argued before courts, and there's several case law that demonstrate the roles played by the IEBC, either by the Secretariat or the Commission, or the Secretariat and the Commission. And we humbly submit one of those very important authorities, which can be found in our digest, is the presidential petition of 2022, E005, Raila Amolo Odinga and others versus the IEBC. My Lord, we submit that in that case, three distinct roles came out clearly. That the IEBC possesses a role where the Constitution references, or where the legislation references the Commission. It could mean the Commission and the Secretariat, as was elaborated in that case, with the issue of verification and tallying. So a reference to the Commission could mean the Commission and the Secretariat. The instruction is to the Commission, but the action is to be taken out or to be handled by the Secretariat. And that can be found on paragraph 46 of that decision. My Lord, the second role would be that if legislation or the Constitution references the Commission, it quite simply means the chairperson and the commissioners. and that role is reserved strictly for the chairperson and the commission. And the decision went on to note that there are such roles that can be taken or handled by the Secretariat, such as this one when we submit. My Lord, from that precedent, two principles clearly emerge from this binding authority. Number one, the Commission acts institutionally, not through personal involvement of the Commissioners, in every function. It doesn't act through the Commissioners in every single function. And that the Secretariat performs the day-to-day administrative and technical functions. So, my Lord and my Lady, the act that is complained about involves no deliberate decision-making by the Commission. It would not require any decision-making by the Commission. It requires no policy formulation, no exercise of constitutional discretion. It was purely factual and database driven, involving retrieval of information held in the voter register, verification of that information, that indeed the individual whom you sought information from is a registered voter, that violated Article 10 of the Constitution. And I have to say apologetically, my Lord, that this prayer is absurd. My Lord, IEBC is being complained of for efficiency, that we delivered information requested in a timely manner. I mean, that is what is needed of government. I have never seen a petition that comes to court to complain about the efficiency of an institution. My Lord, I submit that there was no clearance. We were simply giving information that was contained in the voter register. I humbly so submit. Thank you very much, my Lord.
Thank you very much.
Yes, my lords and my lady, on behalf of the National Assembly, our representation is led by myself. We have Mr. Paul Nyamodi, Mr. Alex Mbaya, Elias Ouma, and Mr. Crispus Kitala. My lords, to support our submissions this morning, we will rely on the affidavit of Samuel Joroge, dated the 21st October 2024. We'll also rely on the 2nd and 7th respondent submissions, dated the 17th of September 2027. We have, in addition to that, filed a list and bundle of authorities dated 2026, sorry. No, 2025. List and bundle of authorities dated the 17th of September 2025 as well. My Lord and my lady, we fully adopt those written submissions. I will, my lords and my lady, start by making reference or drawing our attention back to submissions by learned Senior Counsel Professor Githu Muigai in relation to or on behalf of the Attorney General. I will borrow from his very able submissions on two critical aspects. Number one, on the nature of impeachment proceedings, and number two, on the jurisdiction of the court. In relation to the nature of the proceedings or the nature of impeachment proceedings, learned Senior Counsel Professor Githu Muigai describes those proceedings as proceedings sui generis and political, and he adds that this is not just in Kenya but globally. He then fortifies that position with two critical decisions. One decision is the decision of the Supreme Court of the Philippines, where the court says that impeachments are a constitutional measure designed to protect the state from official delinquencies and that it is political in nature. Locally, Professor Githu Muigai did refer the court to the case of Kawira Mwangaza versus the County Assembly of Meru, affirming that impeachment are inherently political and distinct from judicial processes. My lord and my lady, that being the position taken by the respondents, I then would want to trace the architecture of impeachment proceedings within the context of our Constitution. And I start with this point, my lords and my lady. Every 5 years, the people of Kenya go to the ballot to elect their leaders. In particular, and of most interest, is usually the election of the president, together with his deputy. Then, additionally, the election of parliamentarians. My lords and my lady, these elections determine or define the executive leadership and governance of a country.
Now, central to the question of elections is the issue about the sovereignty of the vote. That under Article 1, Sabbatical 1 of our Constitution, the sovereignty is in the hands of the people of Kenya. It is for the people of Kenya directly making a determination who then choose who their leaders in those respective elective offices would be. That election ordinarily, for context, is by secret ballot. And the reason why I say that is so that we understand that in the exercise of sovereign will, there is no need, there is no requirement for any Kenyan expressing their will to give.
Ever sat staring at a blank page for hours? Yeah, me too. That's why I started using Designer, and now I've
election. The significance of that election is that it forms the basis of a social contract between the people of Kenya and their democratically elected leaders. That determination of governance or election of leaders is not without terms and conditions. Under our conditions, under our Constitution, my lords and my lady, the Constitution spells out in very clear terms what the expectations of the people of Kenya in relation to their leadership should be. Specifically, I draw your attention to the provisions of Article 10 of our Constitution. My lords and my lady, Article 10 of our Constitution, for some reason, has gained prominence over the years since 2010, just on the narrow question of public participation. But I want to this morning, my lords and my lady, draw your attention to the fact that under Article 10, the subtitle is National Values, and more importantly for the proceedings that we have before you, National Values and Principles of Governance. Article 10 then spells out, 10.1 spells out how it applies and how it's supposed to be interpreted and applied. My interest is drawn specifically to Article 10, Sabbatical 2, which says the national values and principles of governance include, then there's A, B, C, and D. Now, those are not mere wishes. Those are the expressions of Kenyans saying that if you are to be a leader in Kenya, then you must lead on the basis of those values. I, for the sake of what is before us, draw our attention to Sub-Article 10(2)(c), which talks about good governance, integrity, transparency, and accountability. Why do I say that? Because impeachments are founded on the basis of good governance, founded on the basis of integrity, transparency, and accountability. My lords and my lady, Kenyans, being fully cognizant of the high authority, high moral authority that they wanted from their leaders, did not stop there. They still, under Chapter 6 of our Constitution, went on to provide for 8 additional articles. The 8 additional articles, my lords and my lady, speak to the leadership and integrity of the leaders. The specific that, then the people of Kenya spell out what they expect of their leaders. Of interest to me is what appears at Sabbatical 1A, Roman 3 and 4. Roman 3 speaks again under that very Chapter 6. Kenyans then make it a cardinal and mandatory requirement that for any public officer to assume office, they must take an oath of office. Now that oath of office is the epitomization of a social contract that I was speaking to. That oath of office, my lords and my lady, takes different forms depending on the office that one is supposed to be assuming. In the context of a president and deputy president, at Schedule 3, that is the third schedule, there is a very clear indication as to what that oath is supposed to be. It says, I, so and so, in full realization of the high calling I am. Says that I will obey, preserve, protect, and defend its constitution, this constitution of Kenya, as by law established, and that all laws, together with all laws of the republic, and that I will protect and uphold the sovereignty and integrity and dignity of the people of Kenya. I underline protect and uphold the sovereignty, integrity, and dignity of the people of Kenya. A similar oath of allegiance is provided for by the deputy president. When you get time, my lords and my lady, you'll take an opportunity to look at the nature of the oath. What is the significance of this oath? My lords and my lady, we submit that the oaths are a solemn commitment by the leaders to uphold the Constitution. It also creates public and moral binding commitment to uphold the sovereignty, integrity, and dignity of the people. And more importantly, that it is the accountability pledge in the social contract that I spoke to. At a later part of my conversation, or rather my submission this morning, I'll refer us to the consequences that the failure to adhere to these conditions or the terms of engagements would lead to in respect of leaders at one level or the other of government. Of interest, and just to show how significant the question of the integrity and this commitment to these articles, the provisions of Article 10 and Chapter 6 are, the President, upon assuming office under Article 132 of our Constitution, is given a duty which is akin to reporting on how they are performing. Under Article 132(1)(c), which under the title Functions of a President, it says, once every year, report in an address to the nation on all the measures taken and the progress achieved in the realization of national values referred to in Article 10. It means a responsibility is put on the President or on the President to then report on the measures they've taken in the realization of Article 10. That just tells you how significant how important that provision is to the people of Kenya. Now, that defines to a large extent how the executive arm of our government works. The people of Kenya then do not stop at that. They say that in order that we hold you accountable, we must then have an arm of government that deals with or that keeps you on check, that exercises oversight over these elected leaders. Now, it is important to then make reference to Article 1, Subarticle 2, that the people of Kenya can make these sovereign decisions either directly or through their democratically elected leaders, so that then the source of authority for parliamentarians, for instance, is as a result of being the democratically elected leaders. And I'll speak to why that is important. I draw your attentions, my lords and my lady, to Article 93 of our Constitution. Article 93 of our Constitution establishes our parliament. That our parliament consists of the National Assembly and Senate. Now, at Article 94, the people of Kenya go on to determine what the role of parliament is. My lords and my lady, I am sure we'll have an opportunity to read the entirety of Article 94. But for purposes of a presentation that we are making before you on the submission, I draw your attention to the provisions of Article 94, Subarticle 2. It says, the Parliament manifests the diversity of the nation, comma, manifests the diversity of the nation. It means that is where every single section or, if you wish, person or member of any class in Kenya is represented in parliament. It takes into account the minority. It takes into account each and every community in Kenya. It goes on to say, it manifests the diversity of the nation, says, represents the will of the people. Read this in the context of Article 1, Subarticle 2, that Parliament represents the will of the people. That when parliamentarians speak, they do not speak as parliamentarians. They speak representing the will of the people. And more importantly, under that 94(2), and exercises their sovereignty. Again, read in the context of Article 1, Subarticle 2, it gives those people, the parliamentarians, the power to exercise the sovereignty of Kenyans. Now, this is a complete surrender in the constitutional sense, that Kenyans surrender their rights to their democratically elected leaders to be able to make decisions on their behalf. And from a craftsmanship point of view, one would want to argue that once we have elected our leaders, we cannot, every time we think there's an infraction of any aspect of a constitution, we then call Kenyans into a plebiscite. That is why we have leaders who then, in the event that there's such an issue, can speak for the people of Kenya. Now, I then draw your attention to the provisions of 94(4), that which say that Parliament shall protect this constitution and promote the democratic governance of the Republic. Again, promote the democratic governance of the Republic. The Constitution then, under that Chapter 8, goes on in a slightly more granular sense at Article 95 to say, that is the role of the National Assembly, to say the National Assembly represents the people of the constituencies and special interests in the National Assembly. In particular, I would draw your attention to 95 Subarticle 5, which says the National Assembly reviews the conduct in office of the President, the Deputy President, and other state officers, and initiates the process of removing them from office. My lords and my ladies, that article does not give us any option. It says the representatives will review the conduct of our elected leaders. Separation of powers. If they find that any of the conducts does not fit within the confines of Article 10 and Chapter 6, then the instructions from the people of Kenya is very clear. Initiate the process of removing them from the office. Role of Senate at Article 96. I refer, my lords, to Article 96, Subarticle 4, that the Senate participates in the oversight of state officers by considering and determining any resolution to remove the President or Deputy President from office in accordance with this, with Article 145. My lords and my lady, why is this important? It is important because we see a textual commitment, and this was a submission made by Learned Senior Counsel Gideon Muigai. There's a textual commitment of this oversight responsibility to the parliamentary arm of government, that is the legislative arm of government. We then are drawn to, maybe just so that I conclude that, an explanation under Article 96. Now, this oversight is exercised in differently in different jurisdictions. In Kenya, the Constitution at Article 145 and Article 150 dictates that it is through impeachment. In other places, it is through a vote of no confidence. Both those processes, as submitted by Learned Senior Counsel and with the support of authorities, are political processes. That's why it is important for us that we appreciate why we appreciate the defining four corners of an impeachment proceeding and the role then subsequently of the court. I also add that the manner in which this legislative arm of government exercises its authority is by, number one, deliberating, as we saw in the proceedings before the National Assembly, as well as in the proceedings before Senate. They deliberate, they interrogate, they question, After they've taken an informed position, my lords and my lady, they vote. That is how parliamentarians make their determinations. Now, that is how they express the will of Kenya. That is how they express the sovereignty of the people of Kenya. It then follows that a test that is to be applied in determining whether that exercise of that will and sovereignty was done properly can only be a political test, and I explain why. If we, for instance, conflate that test to be a test in the judicial sense, then the Article 10 and the values that is ascribed, then it immediately run into challenge. Because when we say, for instance, good morals, how will the court determine good morals other than by being subjective? There's no standard through which the court would say this is a good moral, this is a bad moral. That is why the people of Kenya say our elected leaders will determine that for us based on those specific provisions of the law. I want to give this in the context of Article 145, Fred Mutatis Article 150. Look at the grounds of impeachment, for instance, under Article 145. One of the grounds is that the existence of or rather serious reasons to believe that the president or the deputy president, as the case may be, has committed an offense. Now, from a political perspective, the test is purely a prima facie test. I'll be looking at, having listened to what has been presented, what do I make of it? Having heard what has been said, what do I make of this judgment from a morality perspective? If that same question was to be presented to the court, then there are defined standards. For instance, in relation to issues criminal, it is beyond any reasonable doubt. So it means those two tests requirement that a parliamentarian or a member of the National Assembly voting one way or the other assigns a reason as to why they voted how they voted. That vote is assumed for all intents and purposes to be the expression of the people who elected that person to that National Assembly or to the Senate, as the case may be. That is the same position taken by the Supreme Court in the Sonko case, which is part of the decisions that we've cited in our bundle and list of authorities. The court then says, courts should be slow to interfere with the exercise of parliamentary discretion, and the mandate of the courts is restricted by the doctrine of a separation of powers to deciding on individual rights and fundamental freedoms. In other words, the processes that are submission to the findings of how the Speaker of the National Assembly deals with those requirements. But the sum of it is that the Speaker of the National Assembly satisfies himself at page 745. Let me just try and get the page 745. As to the two tests, both under Standing Order number 64-1 and Standing Order number 64-1A, that both those conditions have been met. Now we go to the second test, and I'll take you just in a short moment to the Hansard to speak to this. We go to the second test, which is the threshold test. Now, the motion must be supported by at least, in the words of the Constitution, if a motion under clause, a member of the National Assembly supported by at least a third of all the members. So the first threshold test is that the motion is supported by at least a third of all the members. I'll draw your attention to how the Speaker of the National Assembly deals with that, determining that question. He makes an express finding that all the members refers to all the members elected, and he gives a specific number as to what all the members mean. He then gives a mathematical representation that for that threshold to be met, there must be at least 117 members supporting the motion that is presented. In the case at hand, my lords and my lady, the number of people who supported the motion was 282. Sorry, 291, members of the National Assembly supported the motion presented by the member for Kibwezi. Now, the second test is under Article 145(2), which says, if a motion under Clause 1 is supported by at least 2/3 of all the members of the National Assembly, now the second threshold test under Article 145 Subarticle 2 is 2/3 of all the members of the National Assembly. Again, the Speaker of the National Assembly, at the conclusion of that exercise, makes a finding as to the number of people who supported or voted in support of the motion. In particular, they say 291 out of 349 members voted in support of the motion. That is what learned Senior Counsel Professor Gidu Muigai referred to as a super majority. My lords, in terms of compliance, are fundamental. I want to take a quick moment to just draw your attention to the specific area where this is to be found in the communication from the chair. Yes, I'm there, my lords and my lady. The Hansard runs from page 744 in volume 2 of the annexure SN3 of the affidavit of Samuel Njoroge. My lords, my lady, after identifying the specific issues of concern, the Speaker at page 748 says, having examined the notice of a special motion by the member for Kibwezi West, I find the special motion meets the requirements relating to the form and threshold set out in Articles 145(1) and 151(b) of the Constitution and Standing Order 64. Then goes on to say, I have also satisfied myself that the number of members who have appended their signatures in support of a special motion exceed the minimum threshold of 117 members. Then further on it says, having determined that the special motion is admissible, let me now focus on the next step of giving notice to the special motion to the House. Understanding Order number 47, 4A, which provides that with respect to the motion of removal from office, a member shall give notice of a motion in the House within 3 sitting days following the approval by the Speaker. Now, that, my lords and my lady, when you get an opportunity, is how the Speaker of the National Assembly deals with the threshold questions. We submit on behalf of the National Assembly that those thresholds were met. After meeting the thresholds, what then do we address our minds to? We stop there, my lords and my lady, to ask ourselves a number of questions that arose in the course of the presentation before you. Learned Senior Counsel Paul Mwite, supported by Counsel Mr. Kibe Muigai, Mr. Ndegwa Njiru, and even Mr. Ogada, described the pace at which the impeachment was to be done. A reading of the entire Article 145 gives a total of 19 days within which the impeachment process should have been completed. And my lords and my lady, that said, if you calculate the 2 days, the 7 days, and whatnot, it gives you a total of 19 days. That said, my lords and my lady, the question of the timely and expeditious determination of an impeachment motion is a dictate of the Constitution taken by the either National Assembly or the Senate. Those timelines are cast on stone, and they must be done within those timelines. Now, it is not unique when we're dealing with issues touching on the presidency because of the sensitivity of the presidency to a republic. Under Article 145 of 140 of our Constitution, any question as to the validity of election of a president is determined within 21 days. Again, under Article 144, a motion for removal of a president for incapacity is to be determined within 30 days. What do we read from these very tight timelines? We read the history that we've walked, that in dealing with these matters, which are obviously possibly divisive and also very contentious, if you leave parties to attend to those processes as they would, we would not be able to make those determinations within the contemplated timelines. My lords and my lady, that is the nature of our Constitution. Learned Senior Counsel Paul Muite then also submits that impeachment is a nuclear option and should be the last resort in dealing with disciplinary issues around a presidency. I mean, around dealing with impeachment of a president or his deputy. My lords and my lady, contrary to that, Article 10 and Chapter 6, couched in very mandatory terms, speak to what I'd call the political hygiene of the country. They determine what follows, and remember in the course of my presentation, I said I'll revert back to Chapter 6. At Article 75, my lords, 75(5) says, no, 75(3), sorry. A person who has been dismissed or otherwise removed from the office for contravention of the provisions specified in Clause 2 is disqualified from holding any other office. That is an important dictate of the Constitution. It doesn't give us an option. It means in black and white that to the extent that His Excellency, the Deputy President, was found to have been in breach of this Chapter 6, specifically the ones referred to Sabbatical Clause 2, which is to be read with Article 10 and Article 73. Once he is impeached, the Constitution says he is disqualified from holding any office. I underline any office. It is not just about the presidency, it is about any public office. And I think that answers the question that learned senior counsel posed to this court. It will be an office either at the national level, at the county level, at the constituency level, and I dare add, even at the county assembly level. Any office that is defined under Article 260 of our Constitution, the test being a simple one. Will that office require that the payment to that office holder be made from the consolidated fund? So the long and short of it, my lords and my lady, is that this article is a bar, unless changed through any other process, is a bar to His Excellency the Deputy President from holding any office, any public office. I go to the next question around fair hearing. This was submitted to quite at length by my learned and good friend, Mr. Dudley Ochiel. I want to add that from a factual perspective, and this is available in the Hansard, each of the senators, each of the members of the National Assembly was presented with the volumes or the documents that contained the petition. The first respondent, His Excellency Rigathi Gachagua, then the Deputy President, was given an opportunity to respond, which, again, as you'll see from our Hansard, he very ably responded to in writing. He was again given an opportunity to attend in person before the National Assembly and before the Senate. Again, he seized that opportunity and attended. He did not just attend alone, he attended with a battery of at least 14 lawyers. That is what the law contemplates. Now, the lawyers were given an opportunity to ask questions, and the Hansard will bear me witness. I'll refer you to the specific aspects of the answer. That the lawyers representing the Deputy President then had very robust engagement, questioning each and every of the grounds that was represented or that was tendered for purposes of the impeachment. After that, the members of the Senate, just like in the National Assembly, were given an opportunity to ask questions. Why is that important? It is important because it shows that these two houses were given an opportunity to interrogate. And interrogation here is so that they're able to make informed decisions. My learned colleague Moses will address us at a later stage on the question of public participation. You will see how that public participation played in. The only point I would want to make is that when that public participation was conducted, it was conducted so that the members of the National Assembly and Senate alike could touch base with the people they represent to see what their thoughts were in relation to the question of impeachment. It is not for this court, I add. It is for the members of the National my lady, that brings me to the central question in relation to that issue. The central question is in relation to the adjournment that was declined by the Senate. Let me say this. I will refer you to the provisions, or rather to the recordings in the Hansard, on how the application for adjournment was made by learned senior counsel Paul Muite. My lady, it is apparent from those proceedings that no ground or no evidence was presented before Senate to enable them, to support the exercise of discretion. With the material that was available before Senate, they made a determination on the basis of the fact, and they did ask this, that the proceedings before the House were time-bound proceedings. They put a specific question to learned senior counsel Paul Muite. What do you want us to do? My lords and my lady, I refer you to the specific answer that was given by learned counsel Paul Muite. Now, not a single piece of paper was presented to the Senate for them to be able to make a determination as to the allegation of ailment. Why is that important? It is important for this reason. The petitioners have come before you to try and question the exercise of discretion of the Senate in denying the motion or the application for adjournment. It is very clear that whilst in Senate, they did not tender any material to support that application. I underline any material. Learned senior counsel, the Honorable James Orengo, and this is captured in the Hansard, speaking to this same process, says at the very least he would have expected at least a doctor from Karen Hospital to come and confirm to the Senate the condition of His Excellency, the Deputy President, then. That did not happen. That, my lords and my lady, we are seeing an affidavit emerging from the woodworks today. Of what probative value? If you're being invited, my lords and my lady, to evaluate the material that was before the Senate at the point at which they were making that determination declining the adjournment, what is the value of an affidavit being filed before you today to support that application? My lords and my lady, it must be abundantly clear that that application is not being made before this court. This court is merely being invited to review the manner in which Senate exercised its discretion. I dare add that absent any supportive material, then Senate had absolutely no basis of granting the orders that were sought. My Lord, it should not be lost that even in Senate, and this is also evident in the Hansard, the petitioner, His Excellency, the Deputy President, then Rigathi Gachagua, was represented by a team of 14 lawyers. That is on record. My lords and my lady, are we saying that out of these 14 lawyers, none of them would have imagined that it is important to lay a document to satisfy the Senate or to give grounds for the adjournment that they were seeking? We think that is a far cry. That was a deliberate omission. This court cannot now go into looking for reasons that ought to have been looked at, or items or material that ought to have been looked at by the Senate, but which were never quite placed before the Senate. It means that the affidavit that has been presented by Dr. Dan Gikonyo before the proceeding, I mean to support the proceedings before you, is of absolutely no value, because no material can be introduced. And I would equate it to the court proceedings. My lord and my lady, if I was to make an application before you today, my team leader, learned Professor Githu Muigai, is not in, and I just say, I want us to adjourn these proceedings, important as they are, then I tell you, I suspect that is unwell. Chances are the court will say no. If the court says, I have not established the grounds for grant of that adjournment, would it be open for me to now go to the Court of Appeal to say that I now have a document 1.5 years after the application has been made? I want you to look at this affidavit. It confirms indeed that the person in issue was actually unwell. That material, having been missing in the proceedings before Senate, cannot be used as a basis of making a determination on that on the exercise of that discretion one way or the other. My lords and my lady, I would want to very quickly, I'd said I'll refer the court to various areas within the Hansard that speak to these items. In the third and fourth respondents annexures, marked as part 4, this big volume, unfortunately it's not paginated, they are the proceedings of the Senate, specifically at page 7, where Learned Counsel Paul Muite makes the application for adjournment, and it runs all through to page 15. My lords and my lady, I ask that when you get an opportunity, just read for yourselves and you see the deliberations as they unfolded before the Senate. There's then the communication by the chair of the Senate, which appears at page 15 after that of the same document. Again, the reasoning of the Speaker in relation to the question of adjournment, ultimately putting the matter for resolution by the whole House. My lords, that is the part of this Hansard which speaks to how the application for adjournment was made. I need not read the whole of it in the interest of time. I'm sure the court will find an opportunity to read that. I think I've referred the court to the specific parts of the Hansard from page 744 of volume 2, annexures running from page 711 to page 1301, specifically page 744 running through page 746 up to page 749. My lords and my lady, that is how the National Assembly deals with the issue of the issue of threshold. Yes, my lords and my lady. So we then ask on behalf of the National Assembly that you find that the petitioners have not met the threshold for you to exercise the review that they're inviting you to exercise. I want to add, as I mentioned earlier, that the review that is supposed to be before you is a review of a determination arising out of a vote. Is it the sort of review that is contemplated in these proceedings? I say, or I add one point to that, that because the members of the National Assembly, the members of Senate, are not required under Article 1, Subarticle 2, to give the reasons as to why they voted however they voted. What would be this reason that would be testing if we were to apply a test, for instance, of Wensbury and reasonableness under the anisminic sense? There'll be no reason that we'll be looking at. From a political sense, my lords and my lady, the only solution left is by the people then saying that that specific member of the National Assembly did not express our will. We will deal with them in two ways. The Constitution says either you deal with them at the point of re-election, or you deal with them through a recall, not in the manner in which we seek to want to, in a granular sense, lay blame on the findings of the members of Senate. I pray that the petitions be dismissed. May I now cede the ground to my learned friend, Mr. Mushemi, to make his presentation. I'm most obliged.
Thank you, my lords and my lady. My name is Michael Mushemi. I appear for the 9th respondent. Your lordships, we are relying on our replying affidavit dated the 22nd of October 2025. Our submissions dated 15th February 2026. Our supplementary submissions and list of authorities dated 5th of May 2026, and our further list of authorities dated the 12th of May 2026. Very briefly, my lords, since the enactment of the 2010 Constitution 16 years ago, Parliament has only met the threshold of 2/3 majority on any bill or any motion on 2 occasions. The first of these occasions was during the passing of the BBI bill, the now defunct bill, where on the 7th of May 2021, the National Assembly approved that bill with 224 members in support and 63 voting against. And in the Senate, on the 11th of May 2021, with the bill being passed by 51 members, 11 voting against and 1 abstention. My lords and my lady, my client, the 9th respondent, brought this motion pursuant to Article 145(3), and in historic numbers, first as required by the Constitution to garner 117 signatures, he was able to garner 290 signatures of members of the National Assembly to present this motion. And when the motion was tabled on the 27th of September 2024, and subsequently debated on the 8th of October 2024, as has been submitted by my learned colleague, Mr. Gumbo, the motion was supported by 282 members, representing 80% of the whole House. This was not just a majority, but a supermajority. when the motion went to the Senate and the vote was taken,